The Special Investigating Unit says it's considering its legal options following a court order barring it from including Eastern Cape Premier Oscar Mabuyane in its Fort Hare University alleged academic fraud investigation. Mabuyane successfully launched an urgent interdict to have the SIU remove him from the investigation. SIU spokesperson Kaizer Kganyago joins us now on the line for more. Thank you so much for joining us this evening. So now, Eastern Cape Premier Oscar Mabuyane launched a two-pronged application in the Eastern Cape High Court related to his enrollment at the university. Could you explain the two varying aspects of that application for us?
Thank you very much, and thank you to your viewers. The application was done in two parts. The first part was dealing with the interdict itself, and the other, which is part A, and part B was the one that was dealing with the merits of the case. Therefore, what was the order today was only dealing with part A, which was then dealing with the interdict, and it was purely to say, let's wait until we are done with part B of the proclamation of the court case.
So the Premier argued that the investigation into him specifically was unconstitutional because it went beyond the scope of a proclamation signed by President Cyril Ramaphosa. This could be remedied with a simple motivation to the presidency to extend the scope of the investigation. Will you be pursuing that?
Yeah, we have indicated that we are looking into all the options legally that we have. And that is one of them. And we said, if you have seen our statement, we said in the statement that we are happy with paragraph 66 of the judgment. That clearly indicates what you are just saying now, where it says that if we've got evidence and to that effect, all we need to do is to go to the president and ask for a amendment or sort of to amend the proclamation. But these are some of the things that we are looking at, and many other of our legal options that we have. But we are happy that it is written like that in the judgment.
So Premier Mabuyane also argued that the SIU was not empowered to investigate educational matters. Now, your lawyer, Gilbert Marcus, disagreed. Could you expand on that for us? Because that's very pertinent to the reason why this interdict was granted.
That cannot be true. You will understand that we do investigations on the basis of processes. And it is not up to us to create policy. It is up to us to make sure that policies are followed up. Therefore, if processes are followed and are followed to the letter, we don't have issues. Therefore, that's the one part. But the second part with our investigation, in a case where we get into any investigation and we find that there are some specialist areas. I'll just give a simple example. If we are investigating a road construction and we need quantity surveyors to understand whether there is value for money, we go and acquire the services of a quantity surveyor to do the work. Therefore, in any investigation that we do, even in this particular investigation, if there is a need for a specialist on educational matters, we will do so and acquire those services for the purpose of our investigation. Therefore, you cannot say that we are not geared up to investigate anything, because we can get those specialization people and deal with those issues that we are supposed to deal with.
And more to the point, you're not investigating education itself, you're investigating fraud and corruption within an education setting. My next question, the second part of this probe, when is that expected to be heard, and what are you expecting?
Obviously, it is up to the court to determine when the Part B will be heard, and we will then deal with that in terms of the program of the court. Therefore, we hope that it can be heard as quickly as possible so that we can move forward, because there are a lot of things that are being said in the public space, especially today, that really are really trying to damage our image, and we are really worried about it. For an example, we heard that Premier Mabuyane is saying that we misled the president by using a report from Fort Hare wrongly, and that is something that we need to reject with the contempt that it deserves. We do our own investigation. If we use the report, we would have used it for the purpose of saying there is something for us to investigate. But at the end of it all, we do our own investigations and we come up with our own findings. And that is why, even with this particular instance, people think that we have lost in terms of merit, but we have not. It is the issue of the interdict only, but at the end of it all, they can only review the things when we have made at the end of the day, we have made findings. But in this case, we have not even arrived at the findings. He is only stopping us from even investigating so that we can get to the findings.
So the scope of the investigation into alleged corruption surrounding qualifications from Fort Hare University is much wider than the part of the investigation pertaining specifically to Premier Mabuyane. But does today's interdict affect your ability to continue with the rest of that investigation?
No, it doesn't. And it has been made very clear in the court ruling today to say that they are only interdicting as pertaining to Premier Mabuyane only. And that is why in our statement we say we are happy that this interdict does not suspend the investigation in its entirety, because we will continue doing what we're supposed to do in as far as other investigation. People must remember, we are not only investigating qualifications at Fort Hare. We are also investigating tender processes. There is a air conditioning tender that we are investigating. There is a gardening tender that we are investigating, but also qualifications.
So there are a number of technicalities involved here. Should you get that additional scope or mandate from the presidency, including master's degrees in the wording of that proclamation, do you think that this interdict would be lifted?
We do not want to preempt the courts, and also we do not want to preempt what our next move is going to be at this stage, because we need to look at all the options. But at the end of it all, we want to do what we are expected to do by the people of South Africa, and we will do what we expect to do without fear or favor. At the end of it all, we are looking at corruption investigation that we are doing, and if people have not done anything wrong, we come out and say so. And it's not like we just do it for the sake of doing it so that we find people guilty. There are instances where I can give you examples where we found there was nothing wrong. And for an example, when we're doing the PPEs, there was allegation that former Premier of the Free State's children got tenders in an unlawful manner. And we investigated and we found that they did not, and we did what we were supposed to do.
My last question before I let you go. Premier Mabuyane is accusing the University of Fort Hare of targeting him. Have you found there to be any malice against him specifically?
I don't know, because this is not something that we do. We don't know how he relates to the university and whatever he's saying. And also you will see that he is accusing the SIU of the same kind of malice. But what we like about it is in the judgment itself, I think it's paragraph 83. It reads like, the paragraph says, although the applicant, which is him, Mabuyane, contend that the SIU was malicious, there is no evidence of such malice. And basically, there is no way that we would have known when the investigation started that he was going to be fingered in one way or another in this process. Therefore, I don't know whether he has got any issues with the university or not, but at the end of it all, we do what we're supposed to do without fear or favor, and we are not doing it to spite anyone.
Well, thank you so much for that update. That was SIU spokesperson Kaizer Kganyago.